My favorite is the so-called Sweeney case. This is an actual case in Georgia, an unreported decision. This is a young man that won the Florida lottery on a $1 ticket and won $22 million prior to the Georgia lottery being enacted. This was a post-Thomas case. He had a source of funds claim regarding that lottery ticket, although he'd been married for 7 years. He told the trial court that he used a dollar bill given to him by his mother 7 years earlier that he kept in a special place in his wallet. And the effect of it, voila, is I won $22 million, and Mrs. Sweeney, I'm sorry, but it was my lucky dollar. And yet that's the kind of source of funds analysis that is permissible under this gap in the law that we have regarding Thomas. And I think that gap is significant because we've not adopted in Georgia a tracing methodology like they use in Texas and California and New York and these other states that says, here's the methodologies that are permissible. We don't have, that I can find, presumptions regarding commingled assets unless we're going to extrapolate them from the Lurch case, meaning don't put something in your spouse's name, but there's no presumptions regarding commingled assets. Therefore, we use a reasonable tracing approach. This approach, to me, reminds me it's a free-for-all. You know, when I was in high school, we had gym class once a month in which the gym coach would say, there are no rules today. And every time he said that, the skinny guys like me just got the tar kicked out of us. And that's what happens in this free-for-all with a lack of direction, I think, regarding presumptions. Other jurisdictions start with a presumption that all assets are marital property. Everything you can find is marital property. Most states start with that presumption. That presumption is rebuttable. You rebut it in most states by clear and convincing evidence, not all. And then what you do is you place a burden on the party who says the property is mine. Show that the property was owned prior to the time of marriage. Show that the property was given during the marriage. Show that the property was inherited. Show that the property was recovered from a personal injury claim, etc. That's what happens in most jurisdictions. And then they go further and approve one of 6 tracing methodologies. And I won't go through them in depth, but there's the direct tracing theory where you really are connecting dots. There's the California test where you use something called the family expense method. We have something called the marital assets out first test. We have something called the total recapitulation method, and then we have the pro rata method. And I would say to you in Georgia, what method are you using? You are using the method of the Sweeney dollar, in my opinion. And I'm saying you collectively because I'm using it as well. And I believe that what we're doing is we're making up source of funds and commingling rules as we go along. And I think, candidly, it's a disservice to our clients and it's a disservice to the courts. Obviously, we need more direction in that regard, and I think it's a very significant gap in Georgia law that I would like to see us address. I would like to thank Michael and Katie and Natalie for putting these materials together, and to thank the Institute. It's always a privilege to be here. Thanks for listening to me.
I'm always inspired by Mr. Mayhew's presentations, and as hard as I work to try to stay up with the law, I realize that he's pushing the limits so far out there that makes my feeble efforts pale in comparison. He's an inspirational example of